The 21-day trial of the 3 San Antonio officers who were charged with murdering Melissa Perez in 2023 has come to an end. A jury acquitted all 3. But was it a fair trial? A significant procedural blow to the prosecution's case was the judge's decision to deny several of their planned expert witnesses on law enforcement policy and use of force from testifying. The defense successfully argued that these experts had no personal knowledge of the incident and worked only after outside opinions weakened the state's attempt to establish that the officers violated procedure. The defense had many very strong witnesses testify in favor of the officers' use of force. The prosecution attempted to call a rebuttal witness by the name of Chuck Joyner, a former CIA and FBI agent. Chuck is well known for defending a cop in Houston who shot a wheelchair-bound double amputee who was holding a ballpoint pen in 2012. Chuck has a business called Survival Sciences, whose motto is, "Protecting those who protect us." He trains law enforcement, teaches self-defense, writes books. He has a course on report writing and encourages cops to write their reports with the mindset of, "I'm going to get sued."
Hi, Dave Smith with Police One, and I'm here with Chuck Joyner, the legendary trainer, FBI agent, and now you have your own company. Talk about your company for a moment.
I started Survival Sciences to benefit law enforcement and to look at things that were causing them problems, to provide training and also to avoid liability issues. The traditional continuum model has hurt us in the past. It's hurt us with juries, it's hurt us with public perception.
So now what are you doing to combat that? What do you teach to combat that mindset?
Well, one of the things I did, I came up with a modern use of force model, the Dynamic Resistance Response Model, or DRM. And what that does, it just reflects Graham versus Connor. And Graham versus Connor is based on the reasonable officer and the officer's perception. It's all based on the officer's perception of the threat. So as an officer, you decide if there's a threat or not a threat, and as long as you can articulate that later and you can do it accurately, then you're good.
That's one of the real keys. An officer has to understand this is where we talk about report writing to win. How important is that report then?
Well, yes, sir. That's critical. And particularly if somebody gets injured, you should have the mindset, I'm going to get sued. And so write the report with that mindset, I'm going to get sued. And look at Graham versus Connor and look at your own emotions and what you observed and what happened and really articulate the threat. And make sure you do a thorough job articulating that threat. And it could be stiffness, it could be taking a balanced stance, it could be tightening the fist, it could be all these different things that the officer sees and he needs to record those. And I'd also say the responsibility goes on the sergeant or lieutenant who's reviewing that report. They should read it, and if they know that's not adequate, kick it back and make them do it again. It's for the officer's protection.
He's even still employed as a reserve officer for a small Texas city town. And he's been employed there for at least 8 years. And in this case, he was a witness for the prosecution? Joyner was expected to testify the ex-officer's use of force was unreasonable and against accepted police practices, changing his mind from his former stance supporting the officer's decision. They rejected his testimony because the defense successfully argued that the prosecution committed a discovery violation. The defense claimed that the state failed to disclose that Joyner was a current Texas peace officer. The judge acknowledged that the prosecution has an affirmative duty to seek out and disclose such information for any expert who is a member of law enforcement.
We were not made aware that Mr. Joyner had any experience as a patrol officer or a peace officer in the state. It wasn't disclosed to the CD. Given that we're litigating a case involving peace officers in Texas and how they acted in this particular case, that would have been invaluable information to have for us to investigate and interrogate his qualifications as an expert in this particular area. It would have allowed us to get records from Spring Valley Village as to his employment, what his actual experience is, whether he's had any disciplinary issues there. We've been kind of deprived and caught by surprise now with this witness. There's really critical information that wasn't disclosed to us. We got an outdated, incomplete CV, and so feels a little bit like ambush.
May I ask a few questions about? Sure. Mr. Joyner, is the CV that may have your state law enforcement experience, is it available on the internet?
I don't believe so. I believe on my website it has one of the older CVs and not the current CV. I can check right now if you'd like.
Please.
Now remember, he's been employed with Spring Valley now for more than 8 years, so there's really no reason why that wouldn't be on an older version of his CV. Now overall, everything is just extremely sloppy. Now keep in mind, Chuck Joyner is actually an expert in this field. This is where he thrives, and he's actually built a business based on helping police officers maneuver these types of systems. So all these minor mistakes are just not something that would normally happen with him. In addition to that, I can't help but notice how weak and sloppy and unprepared the prosecution seems. Now, I don't know if this was intentional or if it's just a coincidence, but it certainly has me raising some questions.
That he is a member of the Texas Police Association, and in his previous testimony has testified in state courts on use of force against 4 officers charged and against officers so charged in several states in this district, this county, Travis County, Harris County. So there is a basis to determine he's well versed in the application of state law.
And to be clear, Your Honor, my concern is less a matter of qualification, it's a matter of fairness and adequate disclosure of information that we're entitled to under 3914. The very fact that he's a peace officer who ostensibly has TCOL training goes to the very heart of this case. That's information that's in the sole possession of the state. We can't just go get it. It should have been turned over to us as part of the basis for this expert's opinion, and we've received no notice in that regard.
Are you guys able to provide that to them?
It's information that we didn't have, Your Honor. Yes, we had commissioned him for a report. I don't have it. The CV that I have is posted as what was provided to the defense.
I mean, he's testified about law enforcement matters. He obviously worked as a law enforcement officer, but he hasn't provided that information to you?
The fact that he had state law enforcement officer did not come in the initial product, the initial CV. I did not make a subsequent inquiry from him of that. I don't believe it's any intent to deceive anyone. Simply an outdated CV came forward with the product.
As to the TCOL information, I'm not suggesting that the prosecutors have it and didn't give it to us. However, they are constructively in possession of any information that the government has. TCOL is a state agency. They would have an obligation under Michael Morton to get that information, whether or not Mr. Joyner volunteered it. The onus, as we all know, having done the job, is to go and procure that information. So if they know, or should know, that he was a state peace officer, that's basic information that either they should have gotten on their own or at least disclosed to us that he was a Texas peace officer so that we can make an appropriate request under 3914. We've been deprived of that ability. We're now in the middle of trial. We don't know what impact that would have had on experts we might have called, on how we might have examined our experts in this trial. We've been deprived of that opportunity, and so I endorse Mr. Cifuentes' request that Mr. Joyner not be allowed to testify.
So State, did y'all not think about getting that information, or what's the thought process?
Your Honor, Mr. Harris may have some thoughts. First of all, we went on through this in some of the discovery hearings you might remember before trial. The state has no obligation to turn over things that are not written. Okay, there has to be documents, and there are no documents that he's given us that says I watched some other video or Travis Thompson's video, and he doesn't have an obligation to write down that he watched a video. So that's not discoverable under Michael Morton. It includes documents, unless it's exculpatory, and it's not. It's not exculpatory. Unless it's mitigating, it's not mitigating. So this kind of demands that the defense repeatedly make that the state knew something and didn't turn it over isn't required under our discovery rules and our statutory rules with that.
It's Brady, right? I mean potential Brady, right?
Well, what they've been given, we've been reading the report that they've been given, Your Honor. It says, I am currently a licensed master peace officer in Texas. They know that. They have the ability to send out a subpoena and investigate that and get those records themselves. We don't have his birth certificate. I don't know if he was born in Texas. We don't have his school records. If he went to attend school, and just because it went to a government, because he's affiliated with the government,
Well, we're
Provides
talking
no
about potential
obligation on
Brady,
the state.
right?
I'm sorry?
We're not talking about birth certificates or school. We're talking about potential Brady, anything potentially that could have any sort of Brady material, right? You would be,
T-call, where he was
yes.
employed?
Yes, you would be obligated to get that, wouldn't you?
If we had it, if we had it.
If it exists.
Not if it exists, if we have it. If we have it. It doesn't say if it exists. It says if the state is in possession of those
I
items.
disagree with you. I think it is required. It is required to get that information to see if there's Brady for the defense to look at.
Okay, if we have reason to believe there's a report or somewhere that provides that information, then we have an obligation to get it. If we don't have any reason to believe that there's Brady material, we can't be obligated to possess it and turn it over.
And Judge, I think
it's just not the law.
I think, with all due respect, I think Mr. Linden is thinking the old way of doing things. The responsibility is on them to look. So I think that the court is on the right track. It's their responsibility to look. He got close to saying it's their responsibility to do it, and it's not ours. We've all done that job. Mr. Linden's been doing it for 37 years. The rules have changed, and the current status, the court is in the right arena for sure. You know that, Judge. Is that the responsibility is on them to check. Not if they think, because what they think is different than what we think, or we would be having this trial. Because I think they're wrong, and they think we're wrong, and so we're having a trial. So with all due respect, it's irrelevant what he thinks. It's what the law requires, and it requires for him to look to make sure, and then to turn it over and disclose it, because it could be potential Brady. We're not saying it is or isn't right now, Judge, but that's not the standard.
And Your Honor, this particular case and instance even begs for more disclosure, because frankly, I have never seen in the entirety of my career the state, and they weren't even going to tell us until they were pushed, when they go on the record and say, oh, our designated expert, he's wrong. We disagree with him. That is certainly Brady. It goes to impeachment, it goes to Brady, it goes to mitigation. And so, because of that, certainly we'd be entitled, I want to know what his training hours were via T-close, and find out what is, we didn't know. I think 16 hours is usually what reserve officers have to accrue to be a reserve officer. It all goes to his qualifications and...
All right, State, so you're making the argument that Heath does not apply in this particular situation? Is that what you're saying?
No, if there was, he says if we got evidence, we got late. If we got it late and we turned it over late and we should have gotten it sooner, or we had it sooner and didn't turn it over, then the court would be able to exclude that evidence at trial. That's what Heath says. That's all that Heath says. So in that case, it was a 911 call or something of that nature. The state turned over to the defense a day or a weekend before the trial, and the state had the opportunity to get it because it was the PD had it the entire time. The PD that filed the case with them. And I don't disagree with Heath. Heath is fine. We have an obligation, what we have, to get it to the defense. It's something that we have. Not something we don't have. Not something that's in another agency, in another county, in another state, whatever these kinds of things. Now, if we have reason to believe, because the witnesses told us, he was disciplined as a police officer in Iowa, okay? Then we'd have an obligation of going to get it and ferret that out. But we are under no obligation to look up and do a background check on every witness we have to see if they've done anything wrong. We do not.
And as much as I'm salivating to cross-examine Mr. Joyner, Judge, I think it's obvious that it's your discretion to exclude him from this jury hearing from him.
I don't know if it's so much a discretion. It seems mandatory at this point.
Fair enough.
So I'm gonna sustain the defense objection. Anything else? All right, thank you, sir.
So here's what we have so far. We have the 3 police officers who are represented by a fantastic team of defense attorneys. We have a prosecution team that seem to be lacking a little bit in professionalism and in just overall being prepared, which is really weird for such a huge case. We have an expert pro-police witness with over 40 years of experience who has built a business on helping police officers overcome lawsuits, who for some strange reason is trying to be a witness for the prosecution against these officers, which is really strange. We're talking about the same expert witness who were able to convince the DA's office in Houston to not prosecute officers who shot and killed a man who was a double amputee and in a wheelchair for having a ballpoint pen. At first, he sided with the police officer's actions in this case, but then for some reason changed his mind. Another high-profile case that Chuck Joyner was an expert witness in never actually made it to trial, but he was actually hired by Bexar County to investigate an officer-involved shooting where 4 Bexar County deputies shot and killed a nonviolent, unarmed woman that they were chasing, and as a result, in the crossfire, also killed a little boy named Cameron Prescott. But here's the kicker. Guess who hired him in 2017 to investigate the police officers involved in the shooting death of Cameron Prescott? Well, that was none other than District Attorney Nico LaHood. That's right, Nico LaHood, the lead attorney representing the police officers. In 2017, Nico LaHood was the district attorney for Bexar County. And according to court records, he hired Chuck Joyner to investigate. So what I'm telling you right now is that Chuck Joyner and Nico LaHood, they know each other. So what I really want to know is, why did Chuck Joyner decide to become a witness for the prosecution? Did he look at all the facts and all of a sudden decide that, the officers were not justified in doing what they did? I have a hard time believing that, especially coming from the man who defended the officers who shot a double amputee in a wheelchair. Here's a clip from the trial of Nico questioning Chuck Joyner.
I'm going to swear you in.
Yes, sir.
Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, you may need to adjust the microphone and make sure we can all hear you, okay?
Okay.
Can you give us your name and spell it for the court reporter, please?
Chuck, C-H-U-C-K, Joyner, J-O-Y-N-E-R.
All right. You may proceed.
Mr. Joyner, I want to make sure I refer to you properly. Is it Mr. Joyner, Dr. Joyner?
Chuck is good too, but no, it's not doctor.
Not, okay, well,
Yeah.
thank you for that.
Okay.
You call me Nico, but I don't know if they'll want you to do that during court. So are you here to offer an opinion, Mr. Joyner?
I am.
And so to be specific, what subject or area are you planning to offer that opinion in?
Primarily on use of force. I could also talk about police practices and policies, but the main nexus of this trial is whether or not the use of force was reasonable.
Are you aware of the judge's rulings that they told you that you're not supposed to hear any testimony about tactics or plans or anything like that?
I have.
Okay. And so exclusively you're here to talk about use of force and whether it was reasonable?
Yes.
And so what is your opinion on that topic?
That the use of force by all 3 officers was unreasonable.
And so can I ask you, so what evidence did you rely on in order to come to this opinion?
I relied on the evidence that was provided to me by the district attorney's office, which included the body-worn camera videos of several officers. Is this giving you feedback?
It's a little bit. I don't know if you're too close.
It's almost. Is it working now?
It doesn't work, but I can hear you.
Oh, okay. The body-worn camera of various officers, the reports prepared, the affidavits for arrest, the medical reports, witness statements.
Which witness statements and body cam did you review?
The body-worn camera videos were of the 3 officers, Officer Salinas, Officer Rojas, and Officer Ramos.
And Officer Rojas and Ramos was more recent though, right?
That's correct.
And Officer Rojas and Ramos has nothing to do with whether the use of force was reasonable.
That's correct.
So the body cam videos that you reviewed on what you're here to testify to is Salinas, Villalobos, Alejandro, and Flores.
That's correct. Now, the videos from Officers Ramos and Rojas did provide a different perspective of the entire situation.
But that perspective did not change whether these 3 officers behind us were reasonable in the use of force at the time that they used it.
That's correct, and it didn't change my opinion.
Right. So what specifically about each one of the officers was unreasonable? I mean, when you say that you reviewed the evidence, were you applying the statute as well?
Yes.
And what statutes were those?
9.31, 9.32, and 9.51, and also federal law.
Okay. Have you reviewed the federal opinion? by Judge Bentbrock?
The civil?
Yes, sir.
Yes, I did.
And so you disagree with the judge's opinion?
I think they misstated some of the facts. Yes, so I disagree.
In your opinion, you have not perceived some of the facts mistakenly. That's your position today.
I think they misstated some of the facts, so yes, I perceive them
So
differently.
so you perceive them differently, and you feel like you reviewed all the facts.
I reviewed all the relevant facts.
And we'll talk about what that means and what you think is relevant. But specifically as to Sergeant Flores, what specifically was unreasonable about the situation that he was in at that moment?
The short answer is he used deadly force when it wasn't warranted, when it was unreasonable.
And then with Officer Villalobos
Same,
and then Officer Alejandro the same.
same.
Are you aware that at some point, I mean, I'm sure you're aware that you believe that the DA's office felt that part of your opinion at least was wrong.
I am.
What part was that?
When it came to whether or not they were lawfully present and had the right to be entering her home.
And that's important when it comes to reasonableness, right? It's important to be there lawfully. I mean, you can't.
Yes, it can certainly be a factor in terms of whether or not the use of force was reasonable or not, but it also comes down to, did the officers have a reasonable belief that they were there lawfully? Did they have a good faith belief?
And you don't have an opinion on that because you're not in their minds, right?
Well, and again, it's irrelevant to this case, but you're correct.
But you believe that they were there reasonably, objectively.
Yeah, I think they had a good faith belief that they were there lawfully.
And you agree that an individual, I believe it's mentioned in your report, cannot use deadly force against an officer to protect property or to resist arrest.
I don't believe so.
But not just that you don't believe so, the law states that as well, right?
That's correct, except for some circumstances, very extreme circumstances. Pretty much when you're talking about a rogue officer that's now become a criminal and is trying to kill you, and that's your only means of self-defense.
And I think the operative phrase there is very extreme, right, situation.
True, yeah.
Not when an officer is lawfully there and in the commission of a lawful act. It's not.
Yeah, I would never advocate that somebody fight or try to harm a law enforcement officer.
And you agree that this situation here wasn't one of those extreme situations where an individual has a right to use deadly force against an officer?
I agree.
Yes.
Thank you, Mr. Joyner. We'll pass the phone.
I don't know about you, but what I got from this is that Nico was incredibly easy on Chuck. Now, you got to remember, Nico is a fantastic attorney. He's one of the best in San Antonio. His questioning is very strategic, and he doesn't hold back. But while questioning Chuck, he never really dug in and reached for answers. He never asked him about the details and the specifics as to why he felt like the officers were not justified. He kept it short and simple, and then they brought up these relatively minor technicalities that were able to get him barred from testifying. So I think the obvious question here is, are they working together in order to sabotage the prosecution's case?